All right, welcome back, everyone. Ladies and gentlemen, thanks for joining us again at Goyer, Ruano, and Thompson and law offices of Mark Peacock. And once again, I'm joined by my good friend and personal injury expert, Mr. Mark Peacock. And what we're going to talk about today is, since I'm just recovering from PTSD from it, was I just completed a jury trial in the Northern District out of Oakland before Judge Jeffrey White. And it was a multi-count criminal defense trial involving a police officer. And so Mark and I are going to chat about that case a little bit from a 30,000-foot view. Portions of that case are still pending. We got a verdict from a jury last Friday, so just a few days ago. And a lot of things still happening on the case, but it's worth a long conversation, part of which we're going to start today about, what's going on in our criminal justice system, and what's going on in law enforcement as it relates to their ability to do their job in the environment that they and we are all in right now. So, Mark, thanks for joining me this afternoon.
Oh yeah, you've been on a big journey here the last few weeks. That's
living in downtown Oakland.
That's a good start.
Yeah.
So, hey, can I ask you a question?
Yeah.
Just from the get-go, the judge here. What did you think of the judge?
Judge Jeffrey White, really, really sharp, really experienced federal court trial judge. Honestly, he's very, very tough.
Okay.
And sets a rigorous schedule. I really liked him, and I like doing trials in front of a judge like that.
Okay.
It's federal court. I always view federal court litigation, whether it's civil or criminal litigation, it's kind of like the major leagues because usually the quality of everyone in federal court is a lot higher. Yep. From the court reporters to the clerks to the court security personnel, certainly to the judges, and for the most part, with some notable exceptions, the lawyers. Sometimes the lawyers aren't great. We had an example of that in our case.
I'd love to get into that with you.
Yeah, I don't know how much of that I can actually get into. I can probably touch on that because there was a mistrial we'll talk about related to one particular co-defendant. But he set an unbelievable schedule. So this was the 55th case I've taken to verdict over the years.
Wow.
Yeah, I can't believe I've done that many. And I've done federal court, state court, civil, criminal, plaintiff's defense, kind of all different angles. And he set the most rigorous schedule. So we went 5 days a week, Monday through Friday. We had to be in court before 7:30 every day. So we're rolling into court at about 7:20, and he would let you know if you were late. It would be a problem. His clerk rolls into court at 6 a.m. every morning.
Oh, God.
Unbelievable. So we had to be there at about 7:20. We handle pretrial matters, and then we would get to work usually before 8 o'clock, 5 or 10 to 8. If the jury was all there, he'd get the jury all seated, and we'd get going. We take one short break in the morning, an hour lunch. When it was all said and done, it was about 45 minutes on lunch, and then a short break in the afternoon, went till 4:30. But then it was never that easy because at 4:30, the judge we'd have issues, questions, some things would come up.
Issues in a trial?
Yeah.
Oh, interesting.
Yeah. That never happens, right?
Exactly.
And we had particularly a lot of issues in this case. So what typically he would do is order us to research it and brief it and file that brief in the court's electronic filing system by 10 p.m. that night. So the lawyers on both sides would be, we'd be scrambling, working for 2-3 hours, whatever it was, that night, get it filed by 10. The judge's clerks, who are lawyers, obviously, they would then do an analysis, their own analysis, and the judge would issue a recommendation on his rulings on whatever issues were pending by 6 a.m. in the morning. Wow. We would then have to read that in the morning, be ready to respond at 7:30, and have the whole thing sorted out by the time the jury got seated at, say, 5 minutes or 10 minutes to 8.
Wow.
So it was a marathon.
That's 5 days a week.
5 days a week, and then there's a ton of prep. Yeah, we worked on this case, and I got to give a big shout out to my associates, Janelle Crandall and Gabby Turnbull, because without them, I could have never done this case. Yeah. They did a ton of work, and collectively, we did a huge amount of work over the last, this case has been pending for over a year, well over a year, but for the last, say, 90 days, it has been full speed. You and I usually talk multiple times a week, if not every day. And then we went like 3 weeks without talking.
I know.
Because I fell into this time warp known as this trial and
I
lost.
missed you, man.
Yeah, I missed you too, man. And I lost 3 weeks of my life and woke up recently and go,
Well, wait a minute, though.
We're in the middle of March all of a sudden.
Let me ask you a question, though. I mean, can you give a brief description of what the case was all about?
Yeah, that would be a good starting point.
Because you know what? Because leading into it, or where the case goes, you really did a remarkable job. Not just you, but your team.
Thanks.
It's just a remarkable job. And so, if you could kind of frame it, like, what was the case about?
Well, what this case is about is it's our client, Morteza Amiri, was a police officer at the City of Antioch Police Department.
Okay.
There's a lot to talk about the City of Antioch. That's a crazy place. But the federal government, the Department of Justice, and this is not today's Department of Justice. This was Department of Justice from years past because the U.S. attorney out of San Francisco, where this case originated, he was fired. Trump administration fired him, 2 or 3 weeks ago. So he's gone. And but this case originated out of that group, out of that unit. But they indicted approximately 20 police officers from, I believe, 3 different police agencies, Antioch, Pittsburgh, possibly and one other police agency, for a variety of forms of misconduct, and which led to our client being indicted for various counts of excessive force, which is violation of civil rights, which is Section 242, specific code section, make sure I get it right, is 18 U.S.C. 242 was deprivations of rights under color of law. In layman's terms, that means excessive or unjustified force when making an arrest. He was indicted on 4 counts of that, 1 big count of conspiracy, and 1 count of obstruction of justice, falsifying a police report related to one of those excessive force counts. In our particular indictment group, we had 2 other co-defendants. One of the co-defendants flipped on us, Eric Rombau. Thank you very little. He flipped on us. And
during trial, pre-trial?
Just before trial, about 2 or 3 weeks, maybe a month before trial. He worked out some, I don't want to say deal, but it was a non-deal with the government. He didn't get anything out of it. Pled out. And
why would he do that? Any idea?
Fear. I don't know. I don't know why.
All right.
I don't know why he did it. But he agreed to testify against our client, and especially to prove up the conspiracy count.
Okay.
And he testified at length against our client at trial. So, we started off with 3 defendants, including our trial, Morteza Amiri, Mr. Rombau, pled out and flipped on us, ended up testifying against us. And then 2 days into the trial, on the second day, the other co-defendant, Mr. Winger's lawyer, made a motion for a mistrial based on her inability to physically or mentally carry forward and represent our client, which was, after a long argument, was granted.
Okay, let me interrupt you.
Yeah.
I'm not so sure how much you could talk about that.
Yeah,
but
me neither.
Okay, all right.
I'll be careful.
You do you on this one, I suppose. But that particular attorney and what that attorney did or didn't do and brought to the table and what that did to the entire trial, it's fascinating. Because can you, as best you can, describe that without breaching something? Because it really, when you're talking with you one day, the week before all that craziness went down, the trials, it seemed anyway, from the bleachers to be going one way, and then like a week later, craziness happens, and boom, all of a sudden you're looking at a mistrial, you're looking at something else. So if you can comment on that.
Yeah, craziness happened. For sure, craziness happened. A few things happened. Over the course of trial, we scored a lot of points on the government's witnesses. Things went a lot, including Mr. Rombau, who testified. We scored a lot of points, I thought, with him, to the point that we gained an acquittal on the conspiracy charge.
Oh, good job.
Which is
good. That's
which is huge, because that significantly increased the penalty that Mr. Amiri was facing, all the surrounding counts. But
by the way, when you're talking about the things that your client's facing, it's basically jail time.
Prison time, for sure.
Prison time.
For sure.
Go ahead.
Yeah. So, what happened is this case was an immense amount of work, I should say, to be fair. I think there were 75,000 to 80,000 pages of discovery. It is a monster. It's probably the biggest, most complicated case I've ever worked on that went to trial.
Yeah.
And it took Ms. Crandall, Ms. Turnbull and I mean, we were working on it 7 days a week for weeks leading up to this to get it in order. And in federal court, under the judge's standing rules, many things have to be filed way before the trial date. So 30 days out, we had to file all our motions in limine. While our jury instructions had to be filed, we had to meet and confer with the other side to make sure everything was in order. Everything had to be done well in advance. And so then the trial date comes, and the first thing we did was pick a jury, and came back once a jury was selected, which is a whole nother adventure.
Yeah, I was going to ask you, any surprises, or I mean, it usually is kind of fun.
Yeah. It was. Pick a jury was an adventure. So we're in the Northern District in Oakland. So the Northern District of the U.S. District Court has 4 courts. It has the Oakland Court, the San Jose Court, the San Francisco Court, and the Eureka Court. And jurors are drawn generally from that geographic area. So, for example, the San Jose Court draws generally jurors from the South Bay in the Bay Area. The Oakland Court generally draws Alameda County, Contra Costa County, and some surrounding areas of their jurors. And there's some overlap, and then the Eureka Court up far north draws jurors from the north, obviously. So our jury was very diverse in every sense of the word, very anti-law enforcement.
Oh, really?
Unbelievably, of all the trials I've done, this was the most anti-law enforcement jury I've ever come across, in that we knew this going in because we do a juror questionnaire, and the juror questionnaire had a number of questions related to the jurors' experiences or beliefs with law enforcement and law enforcement officers. And an astonishingly high number came back with negative feelings towards police officers, even though they had never had a negative experience with the criminal justice system. In other words, they had never been arrested. Their family or friends had never been arrested. They had never been involved through the criminal justice system on state or federal level, but they still had a very negative view of law enforcement based on the tsunami of media they've consumed over the last several years. And we just had to deal with that. And it was very, very, very prominent to the point that...
Yeah, but how did you deal with that, by the way? Not only in the questionnaire, but, when talking to the jurors, did you address any of that?
100%.
Okay.
And Judge White gave us the opportunity to speak to the jury pool directly.
Okay.
For a limited amount of time. I mean, I talked to him for half a day, given the opportunity, but I think we had 20 minutes or so, give or take, to chat with the jury. And I went directly at that specific question, is their views on law enforcement, because our client, Morteza Amiri, was a police officer.
Yeah.
And I could get every single one of those jurors to agree that I spoke to directly that they had a bias, an anti-law enforcement bias. They would admit it readily. And I could get them to agree that it would not be fair for them to sit on a jury judging the conduct of a police officer. So one thing I will say about jurors, they tend to respect that system. And we ended up actually with a very smart, very dedicated jury, one of the best juries I can ever remember, ultimately. But they take that duty seriously. So, the jurors were very forthright with me about their biases. And that even when I would ask the question, like, if you were in my shoes, would you want a juror like yourself with those biases or prejudices sitting in judgment of my client or somebody like you? And they universally say, no, it wouldn't be right. It wouldn't be fair. So we got a lot of jurors dismissed for cause. And we had, between my co-defendant and our client, we had 20 preemptory challenges. So we were able to sort it out and dismiss the most problematic jurors. But we only had 100 jurors, which is a very low number on a police case. Many times I've done trials where they might bring in 200 jurors or 300 jurors. We only had 100, and when it was all said and done, when we finally had our final 12, plus 4 alternates, we used everybody. We didn't have anybody left. We had no extras. Yeah. So we burned everyone. Between 4 cause challenges and preemptory challenges, everyone was gone.
You whittled it down. You got it. Yeah.
We whittled it down.
Yeah, good job.
And it was a numbers game, and the judge didn't think we were going to get a jury that day. He said, we're going to have to call in a new jury pool like the next day or the day after that. And I said, no, I think we got it.
Yeah.
Because I was talking to the other side about what they were going to do in terms of peremptories, and we knew what we were going to do.
Yeah.
And I was doing some quick math. I said, oh, I think we're going to make it. Barely. Which we did.
Good. Do you ever use jury consultants, by the way?
100%.
Did you on this case?
We didn't in this particular case. We have a lot, and we've done mock trials.
Yeah.
And that landscape has changed a lot. That's something we could talk about on another episode, is with the advent of artificial intelligence, that landscape has really changed. So we use a service now that's basically an online service where you can do a mock trial, or you can even do sub-issues submitted to a pool. And you
Online?
Yeah, online, where you hire this company and then you submit to them some videos of the issue or issues in your case, the whole case if you want to do it. And you submit videos, of all the issues, the pros, the cons. You try to do it objectively. The jury pool out there will evaluate your questions, your case, your issues, and they do it online. And then this particular service is using an AI platform that evaluates their emotions as they fill out the questionnaire.
Wow.
So it can read things like empathy or anger or boredom or so forth. So that helps you get a real read on how average citizens out there are viewing your case. So
that is so fascinating. The evolution of that technology is rapid, so rapid right now. It's unbelievable.
It's at warp speed.
Yeah, I know. So,
you've done trials before. Have you used? Jury consultants?
I've done the old-fashioned mock trials.
Yeah, same here.
And I haven't done any of the AI stuff. But I personally, depending on obviously the nature and extent of the particular file, I have yet to be unimpressed with a mock trial. I have yet to not learn something.
Oh yeah.
And a lot of times it's the hard lessons that you want to learn. You don't want to learn a day of trial.
Oh my God, no.
And I love mock trials. I love doing those big files. Absolutely, absolutely. And jury consultants. Initially when I was trying cases, I thought there was kind of some esoteric weirdo kind of thing. But actually, I find it completely fascinating and more than helpful, because I've had them where they categorize jurors according to temperament or personality traits.
Yeah. Oh yeah. Absolutely.
And then you know how to present evidence.
Right.
And it's just so fast. To me, it's just absolutely fascinating. And a tool, frankly, that a lot of attorneys don't necessarily use.
Yeah, I mean, there's a cost associated with it, no doubt. So you have to have funding in order, or your case has to be worth it. But I've also found, and maybe this is why a lot of lawyers don't want to do it, because they're a lot of work, but it is preparation on steroids.
Oh, I was going to say that. You get your case trial ready 6 months before trial.
Yeah, you've got it figured out.
Yes, yeah. Which is huge.
Yeah, and that puts you in such an advantageous position.
Yes, yeah, that's a big thing.
Yeah. Well, in this particular case, what we did, and I will get back to the craziness that happened led to the mistrial, but in this case, what we did is there was a ton of local publicity in this case.
Okay.
Throughout Northern California, but particularly in the Bay Area. All the local traditional or legacy media outlets covered it thoroughly, but all the social media outlets, it was just this endless banter.
With that, okay, so in this particular case, are you thinking, okay, good thing, bad thing with the press? As you know, and I know very well, the press can be, an absolute enemy of a file. They could destroy things, yet at the same time, they could also help.
Yeah.
So,
I mean, the media in this case was 98% negative.
Okay.
Toward our client. Now, we weren't involved right away. We didn't represent this client initially. And it wasn't until practically trial where we could start telling our side of the story that it got more fair and balanced.
Okay.
But the media was extraordinarily anti my client, anti all the 20 officers involved, took a beating in the media. And the traditional or legacy media, I don't consume it. I don't follow it. Just because I don't trust it. I don't think it's accurate. I think it's grossly exaggerated. At best, it's grossly exaggerated, if not just pure fabrications. And social media postings aren't any better. In fact, they're probably worse.
Oh, they're horrible.
Yeah, probably even worse. Yeah. So I don't put a ton of stock into that. But that's an issue we had to sort through with the jury, is the media exposure they had. And many of the jurors had heard about the case. Now, luckily for us, they heard about there was an avalanche of media exposure early on in the case, and it had been relatively quiet up to the trial. And then once the trial started, it all started over again. But one thing we did do related to all the media coverage is we initially looked at doing a change of venue as to whether we could move it out of the Northern District entirely. And we hired a consultant, an expert on that particular subject who was really good. And anybody who sees this and wants a referral, I'd be happy. His name is Brian Edelman. I'd be happy to connect you up with Brian. He did a great job. So what Brian does is he helps you on a legal evaluation of whether you can get a change of venue motion done. But there's an alternative that Brian suggested that we were going to try. And instead of doing a change of venue motion, which from a legal standard in federal court, unlike state court, is very difficult, if not impossible to get.
I would imagine so.
Can't get it.
Yeah.
But what you can get is an intra-district transfer. So we thought that would be a great idea to move it from Oakland to maybe San Jose. I don't know when we want to move it all the way up to Eureka and have to travel up there. Yeah. But sure, if we could get it, we would have got it. Because we get a different jury pool, a different environment entirely, get it out of the environment where there was the intense media coverage. So with that in mind, thinking that a change of venue motion was going to be virtually impossible, we had Brian do a study or a survey, and he and his team did a media survey of the entire Bay Area with a very detailed questionnaire, sent out hundreds and hundreds of questionnaires, and got a lot of feedback to assess what the climate was out there among potential jurors, both in the Oakland district and the San Jose district and the San Francisco district.
Fascinating. Okay.
Yeah, and lo and behold,
Yeah. I gotta
contrary to my thoughts it was going to come back extraordinarily negative.
Yeah.
It came back, maybe 10%, maybe at most, had a bias toward our client, and Brian, and this is what he does, was he thought,
bad?
No, not bad at all. He says, we can deal with this by just doing an extended jury voir dire, in other words, an extended questioning of the jury, which the judge allowed us to do. And we requested additional preemptory challenges, which judge said no to, but we had plenty as it was. But it was time well spent, I think, because it gave us insight into that jury pool and what they were concerned about and what they weren't concerned about. And what we found is enough time had gone by that the initial media impact had been lost.
Yeah.
Plus, I think what's going on out there is, if you look historically throughout our careers, one of the first cases I worked on years and years ago was the Rodney King case back in Los Angeles in the early 1990s. And, from Rodney King, over the course of time, up through George Floyd, which was during COVID, more recently, there have been these ebbs and flows of very visible on video camera police use of force activity, and then the public's response to that and the media's response to that. And there's been ebbs and flows in public opinion of that. Mm-hmm. And particularly after George Floyd, there was a big anti-police, defund the police movement that was going on, which a lot of jurisdictions, cities, counties, some states partook in. And what did that result in? That resulted in the immediate spike of crime. Okay. And it turns out,
shocking.
Yeah, shocker. There's a shocker for you. And it turns out that regardless of your political beliefs and how strong or weakly you felt about defunding the police, you don't want to be a victim of a crime.
Yeah, exactly. Exactly.
You're screaming from the mountaintops, I don't care what your political affiliation is, if you're a victim of a crime.
Absolutely.
In fact, one funny little story is a friend of mine who had a very, very strong anti-police, defund the police opinion, lived up in Seattle at the time. And remember, there was a group of people, citizens isn't the right word, but people that took over part of the city of Seattle.
I remember, yeah.
And they built their own city called Chaz or Chad or some shit like that. And and they were gonna build this new utopia.
Yeah.
Lasted a few months because they were killing so many people. But anyway, my friend, who was very supportive of this whole movement, very progressive, this is the right way to go. Okay, great. Well, she lived not far from there, and her car was burglarized and her laptop was stolen. And she couldn't understand why there wasn't a full SWAT team call out to track down her stolen laptop out of her car. I go, well, you've defunded the police. What are you talking about?
Exactly.
So she is an example, she's still a very good friend of mine. Her views have changed significantly. So I think that's going on out there. Yeah. I think people have seen the practical reality of, like it or not, fair or unfair, there's a certain percentage of our population, and I don't know what it is, and I don't think it's very high. It might be 5%, it might be way less than 5%, but they cause chaos. Yeah. They commit crimes, they victimize people, They rob and steal, they murder and rape. And that's just the way it is. And I think that's the way humanity is. And so there has to be a counterbalance to that. Otherwise the victimization just spreads.
It's out of
control. So we saw this. So I think that was evidenced in this jury and pool analysis we did, that I think people's views have changed to just become realistic. That there is a place for law enforcement, and more than that, in the law enforcement context, there's a place for use of force in law enforcement for officer safety, but also for public safety purposes, and for bad guy purposes, because there's different levels of bad guys. There's the homeless addict on the street who might steal some, but really isn't a violent criminal, and those people are victimized violently a lot.
Yeah, that's true. That is true.
Yeah, so we went through that process, and Mr. Edelman, based on those results came out, and our team, Janelle and Gabby and I, looked at it and said, wow, it really did. One, we're never going to get a change of venue motion, and two, we're never even going to get an intra-district change. So let's just do some extended jury voir dire, which Judge White granted, and requested some extra peremptories because you can never have too many of those, which he said no to. But so we made do with what we had, and we ultimately got a really solid jury.
Okay.
Yeah.
Good deal.
Really solid. Yeah. So when it all came down and we got down to the last person, we had 12 regular jurors and 4 alternates, and they were great. They were one of the hardest working, one of the most attentive juries I've ever been in front of. Very, very smart people. And, they listened to the evidence. And I urged them at the start of the case is, pay attention to the details, count by count, witness by witness. Each charge had elements, and pay attention to those particular elements and see what the facts are, see what the evidence are related to each one of those elements. And they did it.
I was going to ask you,
God bless them.
For the most part, they
God bless them. Yeah, they did.
They did. Okay.
Yeah, they did. Back to what I was talking about a moment ago, the chaos that ensued.
Yeah, let's get to that.
Well, the chaos that ensued in this particular trial early on was that my co-defendant. So we represented Morteza and Amiri, and our co-defendant was Devin Wenger. Well, his lawyer on our second day...
He was a police officer with Antioch
as well, as was the third co-defendant who flipped on us, Eric Rombaugh.
So all these guys knew each other really pretty well.
They knew each other really well.
Okay.
In fact, Mr. Rombaugh and Mr. Amiri for a time were very, very good friends.
Okay.
And they worked together, and, and part of there was a certain bond that developed between these officers because the city of Antioch is a hellhole. The crime and violence in that city is unparalleled, and which I didn't know until I got into this case. But it's Oakland is very closely related because there's a lot of Oakland gangs that operate in the city of Antioch. So there's a very high gang activity, and throughout the trial, every single witness who testified talked about how they would see on not a monthly basis or a weekly basis, but on a daily basis, sometimes multiple times a day, the results of human beings doing the worst possible things to other human beings. I mean, the murder, the violence, the rape, the mayhem, the dead and injured children was chaotic. And that has a big psychological effect on the first responders that have to deal with it.
Absolutely.
And it created and it forged, I believe it was a part of this case, it forged a culture in the city of Antioch Police Department. An us against them mentality culture, I think, in part, but it also forged this form of gallows humor among them where they all texted each other because they don't hang out together. They're hustling from calls. They'd see each other at a briefing, and that was it. And then they're hustling calls all shifts. So each shift had a text group where there would be 7, 8, 9, 10 people in this text group, including supervisors, corporals and sergeants, and they would text each other constantly. And as part of their culture, these were all on their private cell phones, where they would text things that among themselves, they were all desensitized to it, were no big deal. But outside of that group, when out in the light of day, you might say, oh, that's offensive or that's politically incorrect, and there's a lot of profanity and so on. They exchange funny memes, they're giving each other a hard time and so on. In the context of their culture, perfectly understandable. In the bright lights of federal court put under a microscope, the government's argument was this is outrageous conduct, and it shows the degree of misconduct they're committing. So anyway, on the second day of trial, co-defendant Devin Winger's lawyer, Nicole Lopes, made a motion for a mistrial based on her inability to continue representing Mr. Winger in the trial at that time. And after a long argument, government opposed it. After a long argument, the court granted that mistrial and issued an order under seal.
Yeah. So why is it under seal right now?
Well, it's under seal. The judge issued that order under seal to basically protect the privacy of Mr. Winger and Ms. Lopes.
Okay.
Because a lot of personal and sensitive things were stated as a basis for that motion for a mistrial. And so the judge put that order under seal. Okay. So I'm not going to talk about that.
Okay.
What's under seal. So then once that motion was granted, I immediately moved for a severance where we already had a jury. We had a day and a half of trial under our belt already. We had some momentum going. I liked that jury. I was particularly afraid that I wasn't going to get a better jury. In fact, if we came back again, a week or two or a month later, I was afraid we were going to get a jury that was a lot worse. Okay. And plus we would have wasted a bunch of time and the client's money.
Was your motion opposed?
Yes, vigorously.
Okay.
Now, to give us some context, that various parties in the case had filed a severance motion months before to get away from each other, from our clients, and be tried separately, and Judge White denied those across the board. So then I made a severance motion, and he granted it. So he granted it, I think in part because he didn't want to lose that jury, and we had already committed, we'd picked a jury, and we're 2 days deep into this case. And we're working 16 hours a day, and he didn't want to waste that time, I think. Yeah. But luckily, he granted that motion for severance, and we were allowed to continue alone, which really, I think, worked to our benefit because I'll put this strategically. We were not on the same page with Mr. Winger's counsel as to the defense that was being put on.
Okay.
Now, and part of which is Mr. Winger's counsel felt that evidence was being withheld from her, exculpatory evidence was not being disclosed by the government, that she accused the government of various forms of misconduct, and I don't know the facts supporting those. We did not join in any of those motions or any of those activities because we had no basis in fact in that.
Okay.
In fact, we had a very professional, transparent working relationship with the U.S. attorneys involved in the case, and I never got any hint of information that they were withholding anything from us at all. I mean, it was just business. And we were transparent with them, they were transparent with us, and we were just moving ahead professionally. So,
okay, Paul, this trial is fascinating.
Oh yeah.
So there's all kinds of things going on here. So what is right now? What is the status of everything right now?
Okay, so where we are right now is a jury came back Friday, and they acquitted Mr. Amiri of 3 counts. They acquitted him of the conspiracy count, notwithstanding Mr. Rombau's testimony against him. They acquitted him of 2 of the excessive force counts, which are the 242 counts. They convicted him of a single 242 count, and then they convicted him of a falsification or writing a misleading police report related to that count.
Okay.
So he was convicted of 2 counts. By the way, there was a 4th use of force count, a 4th 242 count that was dismissed by the government maybe 3 or 4 weeks before trial.
Okay.
And that was related to the fact that that particular suspect who was arrested was refusing to cooperate, refused to testify. Okay. And there's a story behind that too, which I can get into later. But so where we are,
he's convicted on 2 counts.
Yeah, 2. Okay, so originally was 6. He was convicted of 2. We consider it a huge victory. Mr. Amiri's exposure has been reduced by 80% probably. Yeah. But his sentencing is set for June 3rd, 2025. So we have a lot of work to do between now and then. He'll be interviewed by the probation department, and we'll see. One comment on Judge White is that Judge White on all these indictments has been sentencing all these officers to prison terms. So I would suspect he'll do the same with Mr. Amiri in this case. So Mr. Amiri will certainly do some time in prison over this. And we are currently considering a few things. So we are considering a motion for a new trial. We're considering a motion for an acquittal, which is called a Rule 29 motion. We did one of those after the close of the government's case, and it was denied, so I don't have much hope for that. There are some appealable issues built into the whole thing, so we'll be filing a notice of appeal within the appropriate time and let that run its course. So that's where we are. The government, I believe, is going to try Mr. Wenger again. I think relatively soon, if I remember. I think I saw a trial date in April, which is coming up next month. Yeah, so that's moving along. So there's still a lot of moving parts. I really can't. There's a lot of things I can't comment on. But overall, I mean, the trial itself was extraordinarily complicated, and I'm just glad we had a really, really sharp jury.
Well, if I could say, I mean, just the way you've, listening to you talk about it and everything like that, it's also, I would imagine that your team and what you guys brought to the table, it was almost the most important thing you could possibly do. Because without that kind of approach, that aggressive approach, that open-mindedness, and being able to make decisions right on the spot like that, real quick, your client might not have had the outcome he's now experiencing, which sounds like an incredible outcome for him.
Yeah, he's relieved, and the client and his family, he has a very close, tight-knit family. So throughout the course of the trial, he had as many as 40 family members watching the trial at certain points. Very close wife, 2 little kids. So the whole.
Well, my thinking is most people don't realize, I think, how complicated a trial like that actually really is. It's not just showing up on the day of the trial and trying a case, but there's post-trial things going on, like the appeals and things you're talking about that could have a direct effect on your client.
Yeah.
And that your approach with your team, you have a great team, and they're aggressive and they're thinking outside the box and working late. Per Judge White's rules and whatnot.
Because we had to.
Yeah, well, I mean, apparently your co-counsel wasn't able to do that. So, I'm just very, very impressed with the whole team approach like that.
Yeah, no, it worked out great. You could not do a case like this without a team.
Yeah.
And you need to be working on it well in advance. We worked on this case for the better part of a year, if not more. But I think the hardest thing, there's not a cookbook recipe approach to doing these cases. Yeah. And Mark, I know you, and I know you're particularly good at this as well, but it's the intuitive little decisions you have to make along the way when the environment's changing around you that make all the difference. And also being able to read people, witnesses, the jury, what's going to be effective, what's not effective, what's counterproductive, what issues to raise. I see lawyers sometimes get in the most ridiculous pissing contests with lawyers on the other side that don't score any points for your client.
Yeah.
Plus reflect poorly. Everyone in the courtroom doesn't like it. Jurors don't like that. And if they get a sense that's going on, it reflects poorly on you and your client. So it's all those little intuitive things over the course of the whole preparation, but then the case itself that make a difference. And I think being flexible too is being flexible, know the case really well, but being flexible to be able to make decisions on the spot where you can see around the corner a little bit and recognize, this is a good opportunity for us. Because,
and you trust your instinct.
Yeah,
in that regard.
You got to, and I do, and I've done this enough. But I was also really impressed with Janelle Crandall and Gabby Turnbull's instincts and their intuitive nature in this case. Because when it came down to it, like that severance motion we requested, we could have very easily said, all right, Judge, give us a mistrial too. And we could have all gone home. Okay, we get a break. We get a break. But I knew at that point, I was getting a really good feedback from the jury.
Yeah,
I had a lot of eye contact. I was getting a lot of smiles from the jury. I had some members of the jury that were nodding a lot with me. We had this vibe going on where I go, okay, they're understanding.
And they're listening.
They're listening. Yeah. They were on the ball. They were smart.
Yeah.
And I go, I don't want to lose this jury. Plus, I felt like we have a lot of good momentum. Plus, I wanted to be away from Mr. Wenger and his lawyer.
Yeah.
Being separated from them was a huge bonus. So all of those little things at the spur of the moment, I go, oh, hell yes, we want a severance. And Janelle and Gabby are like, yes, God damn it, get a severance. And we requested it, and Judge White had denied that very motion months before. And when we requested it, he readily granted it. And I guess the environment changed, and we had a jury, and that jury had already invested the day of jury selection and 2 days of its time.
Yeah.
So he didn't want to waste their time. Plus, the court was working like crazy, so it worked out.
Yeah, it's really impressive that you trust your instinct like that.
Yeah.
And by the way, you know, the judge, I'm sure the judge is picking up on all of that. And so when you move for severance, boom, it's granted.
I'll say this too. At the end of the trial, after the jury was dismissed and the verdict was rendered, the court was very congratulatory and flattering to all the lawyers in case, the government lawyers, and they had 3 lawyers on their side, and then our 3 lawyers for a couple, because we acted like professionals.
Yeah.
And we also cooperated with each other. And I don't know. I mean, I like people, and I engaged with those lawyers. I don't know if they were appreciating my poor sense of humor when we're off the record. I was having fun with it, but we got along.
Yeah.
So we exchanged information. We cooperated. We met and conferred when we had to. We got things done on time for the most part, where it was humanly possible, and that makes a difference.
Absolutely.
And it made a difference with the court too, because we got a great ruling on one of our motions in limine, where we excluded certain text messages that involved our client that were really damaging. And Judge White excluded those, and which was a big part of the case. He excluded those. And, you know, conversation for a later day, but that's a big part of why we did not have our client testify in his own defense. He did not testify, which for me is highly unusual. I almost always have in a criminal defense case, and of course all the plaintiffs' civil cases I've done, you always have the client testify.
Yeah, exactly. Yeah.
And in all my police defense cases, except for a few, probably 85, 90% of the time, I always have the police officer testify.
Okay.
Sometimes I didn't, and we didn't in this case. And we think it worked. We think it was the right strategy, but that was an agonizing decision too. And we didn't make that call till the very last second.
That is excellent.
Yeah.
So you got instinct, teamwork, and you applied it all, and you trusted yourself, the whole team. Your client benefited from it.
I think so, and he's happy. He's happy, even though he's going. You know, even got convicted of a couple counts.
Still, from what I understand, the potential for his sentencing could have been rather dire. Yeah, that's a fantastic outcome, bud.
Yeah, we're happy. We're happy with it. They're happy with it. We still have a lot of work to do. You know, we can talk about this case in future episodes further, and I think certain things are going to unfold in the coming weeks. We'll have more things to talk about.
Sounds good.
Yeah. Well, thank you, Mark.
Yeah, thank you, bud. Thanks
we
for
will,
sharing.
ladies and gentlemen, thanks for joining. Be sure to hit the like button. Be sure to hit the subscribe button, and we will be back with more law and disorder, if you will, from the GRT Law Offices of Mark Peacock podcast. Thank you very much.
Thank you.